The next person we have is Dr. Michael Farris with Convention of States. Dr. Farris, thank you for being here.
Thank you, Mr. Chairman, Ranking Minority Member, members of the committee. Thank you for the opportunity to be here. I am the co-founder of the Convention of States Project, a lawyer, been in practice now in my 47th year. I've argued dozens of cases, constitutional cases in appellate courts, including the Supreme Court of Ohio, 2 cases in the Supreme Court of the United States. And I have litigated an Article 5 case on the amendment process back in the late 70s, early 80s, in a case that made it to the Supreme Court of the United States on the question of the extension of time on the Equal Rights Amendment. I represented 4 Washington state legislators in that case. So I'm one of the few lawyers in the country who've actually litigated an Article 5 case. I've also taught constitutional law at Patrick Henry College. 2 of my former students are now state solicitor generals, Indiana and West Virginia, and 5 of my students have clerked for the Supreme Court of the United States. I do that to say that a lot of lawyers claim to be constitutional lawyers, and my question to people making that claim is, show me the number of laws you had declared unconstitutional, and then we can talk. And so the constitutional issues in this case, sorry, I'm used to this, in this legislation can be addressed today perhaps by asking 3 questions. Why did the founders create the process that we're seeking to use here? The second question is, do the current circumstances that we face in our country align with that purpose and that process? And third, is the process safe? And I'll briefly address all 3 of those questions. It was at the end of the Constitutional Convention process in the last week where George Mason observed that the proposed version of amending the Constitution that was in place at the time had a blind spot. And that is, all amendments were going to be proposed by Congress and all would be ratified by the state. And his speech to the convention basically said, Congress is never going to propose an amendment that limits its own power. And the founders in that day probably said something like, we hold that truth to be self-evident. If they were around today, they would say like, duh, and meant the same thing. And they immediately proposed the change to Article 5 that we now see, to give the states the ability to propose amendments for the express purpose of limiting the power of the federal government if the federal government gets out of hand. That's the reason we had it. It was one more layer of the checks and balances process. We don't want any agency in government. We don't want any level of government having too much power. And the ultimate ability to amend the Constitution essentially unilaterally, not by one state, but by ultimately 3/4 of the states, was a check on the misuse of federal power. That's why we have this process. So that takes me to the second question. Do our current circumstances align with that purpose? Well, I could give you a couple hours worth of reasons that that would be true, but I'm going to do 3 and do them briefly. First, the debt. We are experiencing debt that's in the 30s of trillion dollars, and if it's not exactly there today, it'll be 40 trillion all too soon. It's just out of control by anybody's estimation, and that's calling the debt that's on the books. If you take off the book debts, like all the money that's been borrowed from the Social Security system and not paid back, the actual number is closer to $150 trillion, an unimaginable number. And we've done that by spending for things that are not within the competence of the federal government. And that all comes back to a Supreme Court case. If you want to know which case caused all this, the Butler did it. It's United States versus Butler, where the court said federal spending was not limited to the enumerated powers. If federal spending was limited to the enumerated powers, we would essentially have no federal debt. We would certainly not have the kind of federal debt that we're looking at today. I'll take a second example, education. Years ago, I was litigating a homeschool case in New York, and I walked from the State Department of Education, past the city offices, past the regional office called BOCES, down to the federal offices where the litigation was going on. And I realized that every single level of government that I had just passed had a Department of Education. We do not get more services for kids. My dad was a retired public school principal. We don't get more services for kids by having multiple departments of education. We get more bureaucrats. The founders never gave education as an enumerated power to the federal government. They take our money from the states, they take it to Washington, D.C., they send a small portion of that money back to the states with strings and effectively run the educational programs of the schools. About, on average, 5% of school funding comes from the federal government, and 55% of the rules come from the federal government. It is an out-of-control situation. If we returned that whole process, took it away from the federal government, reduce the power and jurisdiction of the federal government, we would have that problem solved on that particular issue. We're getting the feds out of it and get back to just state and local government dealing with education issues. Third example, one is a special favorite of mine ever since I ended up getting an LLM in Public International Law from the University of London, is the treaty process has just gone awry in our country. Our country adopts about 200 treaties a year. 95% of them never are sent to the Senate for ratification. Some years a little more, some years a little less, but the vast majority of treaties are signed either by the president alone or by the Secretary General of the no, not the Secretary General, but the U.S. Ambassador to the UN or some other diplomatic person. We call them executive agreements. That's a term that the Supreme Court and the State Department collectively made up. In international law, all executive agreements are treaties, but we do not treat treaties the way we do. The reason I do this, I'm sure you're getting inquiries from constituents about the upcoming WHO treaty that President Biden has indicated that he's going to sign as an executive agreement in April. And that treaty turns jurisdiction over from the states over pandemics to the federal government under the general supervision of the United Nations World Health Organization. And so that's the way treaties work. Under the necessary and proper clause, once a treaty's been adopted, then the power to implement that treaty goes to the agency that adopted. That's the federal government, that's Congress. And so what we saw in the COVID pandemic, the states had the ability to vary their processes. We lose that under this treaty, and we lose it without so much as a vote in the Senate. We can stop the federal government from doing this end run around the provision of the Constitution that says all treaties should be ratified by the U.S. Senate by a simple fix that effectively overrides the case that the Supreme Court made on this, which was called United States versus Pink. So those are three examples of how we need to impose fiscal restraints on the federal government, impose limitations on the power and jurisdiction of the federal government. The third topic you'll hear about from others under the application that's before you is term limits on federal officials. I'm not going to address that separately. I'm going to address just briefly the third question: is this process safe? The original process that we were given was checks and balances against the federal government, but there are checks and balances built into this process that prevent this process from going awry as well. In order to have a convention, you have to have 2/3 of the states agree on a topic for the convention. The application that's in front of you has been passed verbatim by 19 other states. And Kansas is maybe 20, but that's a long story. But 19 for sure. And so there's no question about aggregation, but we can't add that to other treaties that have been, or excuse me, not treaties, but applications have been proposed over time. There have been 450 applications for a convention over the course of history. The vast majority of them are still valid and in effect. And if 34 applications on any old topic was okay, then we'd have had a convention a long time ago. That's never been the case. We've always had the rule that you have to have agreement on the topic. So when we get to 34 states, agreement on the topic, then you can have a convention. Well, what's to prevent the convention from changing the rules at the time? The question arises because the argument's usually made. The original Constitutional Convention was a runaway convention. They didn't stick to their topic. Why will this happen? Well, that's just simply a historical lie. That's not what happened. I wrote the definitive answer to that argument in the Harvard Journal of Law and Public Policy. You can get it online for free. I have a few copies here today if you'd like to see them or have them. And it's called Defying Conventional Wisdom, How the Original Constitutional Convention Was Not a Runaway. And if you put my last name Farris in and the phrase define conventional wisdom, you can get it for free on the internet from the Harvard Journal of Law and Public Policy. The basic answer is the states called the convention, and here's what the states told their delegates to do. Render the federal constitution adequate for the exigencies of the union. The phrase only amend the Articles of Confederation comes from a resolution by Congress that has the power and effect of a National Pickle Week resolution. It was basically Congress giving their opinion, because under the Articles of Confederation, Congress didn't have any power to call any conventions. They had very limited power. And so the states called the convention. They told them to render the federal constitution adequate for the exigencies of the union, and that's what they did. The idea that they were only supposed to amend the articles is a flat historical lie that defames the Constitution of the United States. People who call themselves constitutionalists on the one hand, and then claim the Constitution was a result of a runaway convention, are engaged in intellectual schizophrenia at a pretty deep level. The checks and balances say, start with 2/3, agreement on the subject matter. And then you go to the convention. It's one state, one vote. It can't be proportional representation because that's a Congress, not a convention. A convention of states, every convention of states that has ever been held in this country, and there have been many, it's always one state, one vote. In fact, it's a term of international law. Every international convention is one state, one vote. We call them states in international law. And that phrase carries on. It's one state, one vote. That's a structural change. But 26 states, a majority at the convention, can approve a proposed text. Then it goes to the state legislatures. 38 states have to ratify. Now, that means if a single house in 13 states vote no, it's over. You lose, because it requires 38. So 13, one house going off and saying, no, we don't want this, that defeats that state. So 13 no votes in 13 chambers, we're done. The only way you can do this is if you have a sensible amendment, because it is very hard to do something good in this process. Very hard. Not impossible, but very hard. It is impossible to do anything crazy. Just you can't get it done. The structure that's in place is so solid. You cannot do something crazy. Now, there are two kinds of groups that are saying the opposite. One on the far right, one on the far left. On the far right, they're basically functional anarchists. They don't trust any government whatsoever. They don't trust this government. They don't trust their city council. They say every government's illegitimate. They're all doing the wrong thing. It's all bad. We can't run a country with functional anarchists in control. Just doesn't work. And they're saying that the checks and balances won't work because they don't trust any government at any point in time. The other group on the left, they're people that love centralized government. The more centralized, the better it is, including world government. They love things like turning over our pandemics to the federal government under the supervision of the UN. And so those people are also singing this runaway convention. You can't control it. You can't control it if your goal is functional anarchy. You can't control it if your goal is massive centralized government. Their arguments flow from their premises. Their premises are dangerous to this country. We do not want functional anarchy. We want a nation that works. And we do not want centralized runaway government. And that's what we've got in Washington, D.C. right now. We need to do the kind of government that works. That is a constitutional republic where there are limited powers at each level of government and there are functional checks and balances. The founders of this country gave every member of this committee and every member of this legislature authority to act. With that authority to check the power and abuse of the federal government, I suggest that you have the moral responsibility to do so. I would encourage you to vote favorably in this legislation. And I'd be happy to answer any questions that anybody might have.
Thank you for your testimony. Representative, again, with the question.
Thank you, Mr. Chairman, and thank you, Attorney Farris, for being here today. Certainly appreciate you bringing, your testimony with regard to HJR 3. I want to say you brought up a lot of different points, some that, specifically relate to the joint resolution, but then some that don't necessarily, but also just provides some imagery so that we all could understand. So again, just want to say that I appreciate that. You brought up a point about, is this safe? And I appreciate that question, but it led me to start thinking in another direction. So my question for you is, with regard to like the state legislatures, do you know if within this bill there are any safeguards so that we can kind of oversee some of the processes and all of that as it relates to the conventions and actions and things like that? So any input you could provide, I would appreciate.
Certainly. There are a number of states that have passed pieces of legislation. Some are doing it as legislative rules that give the state legislature authority to control the actions of your delegates. They are meaning yours, not just Ohio's. They are the Ohio state legislature's delegates. They represent you. And so just like at the original convention, at the original constitutional convention, New York gave its delegates the instruction, all three of you have to be present to vote for New York. If you're not all there, you don't get a vote. Two of them got mad in July and left. Yates and another guy left Alexander Hamilton there. Hamilton debated, he never voted again because the state's instructions wouldn't let them do it. Delaware gave their delegates instructions that said, you can't agree to a government that denies the equality of the states. That's where the US Senate, the compromise came in, is because Delaware couldn't vote for it unless there was equality of the states in some important fashion. That they thought that the Senate was the fulfillment of that, and that's how we got an important factor in how we got the bicameral legislature. So yes, states can and are in this process giving their delegates instructions. You can give them a variety of instructions. We have model rules, we have model legislation on that, and yes, you can control them entirely.
Other questions for the witness? Representative Brown.
Thank you, Chair. Article 5 of the Constitution states, and I'm just going to read it so that there's no mistake.
Okay.
The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes. Now, if I heard you correctly, you were talking about the convention will be limited to a topic or certain topics. Doesn't this language fail to impose any limitations on any topic which may be raised in a constitutional convention under Article 5?
The question is, what constitutes a call? I'm a constitutional originalist, and so the question, the phrase that's there is the word call, shall call a convention. What is it? One of the factors, a call of a convention contains three things. It contains a subject matter, it contains a date, and it contains a time, a place rather. So a call will have those three elements. The topic, the lessons of history, if we've had 450 applications, and if it didn't matter what the topic was, we would have had a convention on all kinds of things. For example, right now today, if you add the plenary applications, mostly coming from the 1700s and 1800s, but there are 13 active calls for a plenary convention today. That is a convention that can consider anything. And you add them to the number of right to life amendment applications that have been exerted. You could have a convention on right to life right now today, but you can't add them. The same thing is true. You could add them together and get the 16th Amendment reversed. You could add them together and get one man, one vote reversed at the state level. There are all kinds of things if you add them together, but that's not the rule of history and that's not the rule of law. Legislative history is part of what the word call means. And we have definitively settled as a matter of legislative history. We have multiple times had the necessary number for a call if subject matter didn't matter. Now, the litigation that I did in the ERA case held, and recent court decisions have affirmed that case. That is, you can't change the rules in the middle of the stream. If you start out saying you're going to have 7 years for ratification, you got 7 years for ratification. You can't change the rules in the middle of the stream. The same thing is true here. If you start a convention for the purposes of the 3 topics that we have here, you can't change the rule and add a 4th or a 5th or a 9th. You stick to the topics at hand. And that's the way it's always been, and that's the way it will be.
Follow?
Thank you, Chair. So is it your testimony that there is no possibility that if such a convention were called, the proceedings could evolve from a mere suggestion to amend the Constitution into a proceeding where the Constitution may be totally eradicated and replaced by an entirely new Constitution?
That cannot happen, Mr. Chairman, I'm sorry, Representative Brown through the chair. No, it can't happen as a matter of pragmatism and as a matter of law. The matter of pragmatism is whatever comes out of this convention, whatever comes out, has to be ratified by 38 states. Because we're not operating outside of the Constitutional Convention process in Article 5. We're operating within it. If the states, using the power, the implied power of the Declaration of Independence, basically held a revolution and said, we want to have a new thing altogether, and enough states showed up, you could try to do some kind of radical exercise like that. That can't happen inside the Article 5 process. You have to have 38 states ratifying. And anybody that monkeys with the First Amendment, the Second Amendment, the 13th Amendment, the 14th Amendment, the 19th Amendment, lots of amendments, lots of provisions, the separation of powers, the 2-term limits on the president. There's lots of things that would be so clearly voted down that we don't have to give them serious consideration. It's just, we have to breathe and take a little bit of common sense to it. Moreover, if somebody tried that, I personally guarantee, I at least will file the case and challenge them. I filed the first case against the abuse of the ERA and I won, and I'll do it again if that happens.
Follow.
Proceed.
Thank you for your response. I appreciate it. I have some questions about how this would operate. A convention, for example, with regard to the selection of delegates to a convention. I suppose one option would be to let the state legislatures choose delegates from their state to the convention. Another option might be for Congress to require elections for delegates, which could occur in either nationwide, statewide, or perhaps House district races. So what is your understanding or your belief as to how delegates to such a convention would be selected?
They will be selected by the legislature. That is a certainty. Because what it is a convention of states. That's what the founders called it. The first application was from Virginia in 1788. Even before the Constitution had been ratified, the government wasn't operational. And they called for a convention basically to give us the Bill of Rights. And in that document, they call it a convention of states. That is a term of art that has a fixed and knowable meaning. And it's the legislatures that do the calling through, they do the application. The states control the process, just like the convention they came out of. I gave you the examples of New York controlling its delegates, Delaware controlling its delegates. It is the delegates of this state legislature. There is no doubt about it. Can people argue anything? Sure, they can argue anything. The likelihood of that happening is the likelihood of President Biden appointing me to the next vacancy of the Supreme Court. I mean, yeah, I guess it could happen, but you can bet anything you want to bet, and that ain't going to happen.
Final question.
Proceed.
If I may. Thank you.
Because I thought you were going to be the next appointment to the U.S. Supreme Court.
No. My final question, sir, is, and I think this is somewhat related. Would each state be represented equally at the convention, or would there be some kind of, would each state be proportionally represented based on population?
States meet one state, one vote. You can send as many delegates as you want. Our recommendation is you send 5 or 7, an odd number, so that they would effectively, just as at the original convention, caucus together, and whoever had the majority within your delegation would cast Ohio's vote. And so, but it's one state, one vote, caucusing. There are dozens and dozens of state compacts, interstate compacts. And every interstate compact that I've looked at, and I've looked at everyone I know to look at, and every single one of them has the equality of the states as the means of voting. Some of them do it by giving the same number of delegates to each state, and the delegates can vote independently. Other states, they use the one state, one vote system in some kind of variation, but it's equality of the states is the absolute rule for every interstate compact in the country that I'm aware of. And so we would be following that. And there's the Interstate Commission for Uniform Laws that gave us the Uniform Commercial Code and many other things. It's one state, one vote. That's effectively exactly parallel to what would be happening here.
Thank you.
Representative Swearingen with a question.
Thank you, Mr. Chairman. Thank you very much for your testimony. My question was just, and Representative Brown kind of touched on this, the selection of what I understand to be one delegate from each state to the convention would be selected by the state legislature. I'm assuming that would be the House and the Senate. And could you maybe elaborate on what the process might look like? Would there be resumes submitted, vote? How would that occur? Thank you.
Mr. Chairman, Representative Swearingen. A state could, if you wanted to have one delegate, I would not suggest it. Your state gets one vote as a unit. And so you could, if you want to send 50, I wouldn't recommend it. It wouldn't be fiscally responsible and create a lot of problems, but I would recommend 5, 7, some number like that. And the House and the Senate would have to collaborate on the process. We have a set of model rules on how to do that. And the best framework for doing this is, we believe, rules, not legislation. The reason for that is that there have been multiple cases going to the Supreme Court on this point, and that is Article 5 power is held by the state legislature, not by the state government. The governor has no role in the process of Article 5. And so ordinary legislation, the governor signs it. This resolution that you're debating today, or considering today, does not go to the governor. It's this, and so legislative rules can control the process in a fashion that can't really be challenged. And so I would suggest that as we get close to the convention, as we get close to 34, we're at 19 right now and moving, that as soon as possible, but certainly by that time, adopt joint rules that clarify the process. We have models for you to consider. It's really pretty easy. I mean, a lot of states are doing things like the leadership of each house recommends 3 people in this, and then there's a process for getting the 7th. It's the kind of thing you do for creating commissions and joint study things on a pretty regular basis. It's not unusual.
Continue.
Just a quick follow-up. In your opinion, would you advise that the legislature put rules on those? Let's just say they went with 5 or 7 delegates to the convention. Should the legislature put rules on those individuals on how, almost like bylaws of how they're to conduct themselves or make decisions while they're at the convention? Or do you advise just leaving that open-ended?
Mr. Chairman, Representative Swearingen, the model rules we have, I would say, a moderate degree of control. For example, one of the things that we've suggested is that the group name one person as the spokesman for the state of Ohio, that you don't have all of them going off and spouting this and that and the other thing. You could adopt that. You don't have to adopt that. But that's the kind of thing you could adopt. And so you can, but I would not want to tie their hands so that they, every single little thing that they're doing, they have to come back here for direction or guidance. But I would put some big pieces in place, and there, we have some suggestions, but there could be others. The hearing process of adopting such rules would help clarify some ideas that I think would probably be for the better overall.
That's very helpful. Thank you.
Representative Skindell with a question.
Thank you, Mr. Chair. I want to return to the line of questioning that Representative Brown had, which is this provisions found at line 67 through 68 8 in the resolution dealing with one state, one vote. You claim that it's equality of the states is something commonly used in some compacts. I find this provision very troubling because equality does not necessarily mean that it's fair for the citizens. So Wyoming, for example, which has a population of 580,000 people, would have the same vote as state of Ohio, which has nearly 12 million people. So you're watering down the influence of the people of Ohio. They have less of a say-so by population. I find that concept troubling and unfair for the citizens of Ohio.
Mr. Chairman, Representative Skindell, the exact same criticism can be leveled at the U.S. Senate because it is based on the equality of the states. And we represent, the House represents population. Population is an important component of our government, and one House is dedicated to that. Both houses in this chamber are dedicated to, or are divided on a very strict population equality basis. But it's not the only consideration. And it's one state, one vote on the ratification process. That can't be doubted. Wyoming has the exact same voting power as California on whether a constitutional amendment is ratified. It's just the structure of a federal constitutional republic. If we are a pure democracy, and that was the way the Constitution was written and the way the government was framed, and that was the only guiding star principle that we were to follow, then your critique would be well taken. But it's not the only principle, and we're not starting from scratch. We're not writing the process freshly. We're not deciding what should they have done. We're following the rules that they did create. And the rules they did create gave a role to the states. It takes 34 states to call the convention. That inequality that you talk about is bound up there. It takes 38 states to ratify. The equality that you criticize is bound up there. And it's the same thing at the convention. It's states, states, states at every level of the process. It's equality of the states that's inherent in the process at all three stages. And whatever equality in that is to the nature of a constitutional republic, just like the U.S. Senate.
Mr. Chair, follow-up. So you say it's in the structure and it's in the rules. The problem is this application is setting forth the rule. We are creating an unfair situation by requiring equality of the states that have been held to. And we don't have full equality of the states in the Congress because, again, as you mentioned, the House of Representatives is based upon population. So there's a consideration of both. This particular application does not consider both situations, and it leads to an unfair situations for the people of Ohio.
Mr. Chairman, Representative Skindell, if, again, we were writing the process fresh, we could debate whether this was a good idea or a bad idea. We're not there. We can't debate whether the Electoral College should exist or not. We can try to change that. You can change the process for it, but that's the process we got. States matter in electing the president. There is equality built into it because every state legislature that controls every step of the process is based on equality of population within the state. So the voters of Canton don't have more influence than the voters of Toledo, or take any other two places you want. There's equality within the state that is guaranteed as the structure of the process. But if you want us to jettison the equality of the states, we've got a lot of things to jettison. We've got to get rid of the Electoral College. We've got to get rid of the U.S. Senate. We've got to get rid of the entire process of amending the Constitution of the United States, not just one element of it. And so if you think the process is unfair, then the thing for you to do is to call for a convention of the states to change Article 5 to require proportional representation at every stage of the process. There's a way to write that to do that. And if you can get 38 states to agree with you, more power to you. But until then, it's the structure that the founders gave us, and the wisdom of it is for history to decide.
Mr. Chair, follow up. So the structure of the convention is being dictated by us, not some 200 plus years ago by the founders of this country. We in this resolution are saying one state, one vote. We can change that. We can debate that now so that when amendments are proposed and there's discussion at the floor of the convention, there's fairness in the system, not equality of the states, which is unfair to the people of Ohio. My other concern about this equality of the states proposal is that the majority of the states have a lower population than Ohio, and they tend to be less diverse. The more populous states tend to be a little bit more diverse. So when you have this equality of the states based upon just the states, you're weighting it towards a white population and discounting the various minorities, the ethnic groups, and the racial groups within this country. And again, it's unfair. It's unfair to the citizens of Ohio.
Mr. Chairman, Representative Scandell, what is being done in this resolution is not creating law. Ohio cannot dictate the rule for the convention. Ohio can dictate to its delegates how they're going to vote. That's it. And so if 26 states come to the convention instructing their delegates to affirm the natural process, that is, it's one state, one vote, vote's over. Because that first vote is going to be taken one state, one vote, whether anybody likes it or not. That's how the first vote will be taken. And I'm certain that there will be an attempt to change that. When California will make the motion, New York will second it. Interestingly, Texas and Florida, I can pretty well guarantee you, will vote against it, even though they're two of the very most populous states. And so the suggestion that you're creating anything is like this legislature citing a rule of common law as you're making a piece of legislation. You cite pre-existing rules on a regular basis, and this is no different. You're reciting the reality that that's how it is, and you're going to make sure that your delegates are not going to engage in some kind of rebellion that's going to just waste time and end up being defeated anyway.
Representative Thomas with the question.
Mr. Farris, thanks for being here today. Thanks for your testimony. My question is about Texas, and most U.S. citizens would like look at the situation in Texas and would like a solution to the standoff between the state and the federal government. How could a convention of states propose an amendment to fix this issue?
Mr. Chairman, Representative Thomas, well, there are two different paths. One is you could do a standalone application that would just address the border situation, and you could call a convention to say, we'd like a convention to solely address a remedy for the border crisis, and then you would have a convention on that topic. Under our application, since it makes germane things that reduce the power and jurisdiction of the federal government, an amendment that would give states joint jurisdiction to pass legislation to control the border within their state so that you wouldn't have automatic federal supremacy. You could give Texas the right to control Texas's border jointly with the federal government. You could give, and if the feds didn't want to enforce their law, okay, that's fine. Texas can enforce its law. And so that would be germane under our application. So at least to that extent, it would be appropriate. You could also, under our application, if you wanted to say the United States does not have the authority to give asylum to people who came here illegally, an amendment could be crafted for that purpose. That would be germane. Do I think that that is likely to get out of the convention and get ratified by 38 states? Not very likely, but it's just an example of what could happen. Although I think the first example I gave you could get out and could get ratified, where you give joint jurisdiction to the border states so that they can control their borders.
Representative Swearingen with the question.
Yeah, thank you, Mr. Chairman. Vice Chairman Thomas just hit on my question, because not only is our spending just wildly out of control at the federal level, we have a wide open border too. So thank you for speaking on that. My question was going to be, what can we do about the border at the Convention of the States, and I think you just answered that very nicely.
Thank you.
Thank you for your testimony. I have one quick question. And first, I've heard hours and hours of testimony on this issue in the past, and probably have heard you testify in front of me at various times. But functional anarchist is a new term. I appreciate that. I've been thinking about that all the way through your testimony, thinking about the people I know and friends of mine who are now functional anarchists. So I'll have fun telling them that. And not sure whether it's a compliment or picking on it, but my question is, so 38 states need to approve this exactly in the exact form on all three of these issues, correct? And right now 19 have, but it has to be exact, the resolution has to be exactly the same in all 38 states. Is that correct?
Almost, Mr. Chairman. The application phase, it's 34 states have to agree on the topics. And probably you could get away with minor variations on the topic. We're not taking any chances. Every state that has done this has done it verbatim on the operative language, not on the whereases and all the surrounding. But the operative resolution has been precisely this. Frankly, I got into this by going to a meeting in Denver 12 years ago, we'll call it, where we're looking at the BBA, Balanced Budget Amendment applications. And I looked at all the various forms of it, and I go, you guys we'll have a real aggregation problem, because they've been written in so many different ways. And, many of them, for example, say, we want to hold a convention to call for this particular amendment. Well, that didn't aggregate with anything other than calls for that particular amendment. The best way to do it is just say, let's have a convention on balanced budget amendment. But only like 6 states have ever done that. So I spoke up at the meeting and says, why don't we just start over and do it right? And that's where the Convention of States process was born, was on my suggestion, let's start over and do it right. And as long as we're fixing it, let's fix it. Because if you just say balance the budget, it doesn't say you're going to control the spending necessarily, because the mechanisms to do that may or may not be present in a balanced budget amendment. But controlling the spending is the game. And and the real game there is to get them to go back to spending for the enumerated powers. If you're spending on things that are outside the enumerated powers of the federal government, we're always going to be in this crazy broke situation where we're trying to fund everything for everybody. It's unsustainable, and our country shouldn't have to put up with it anymore.
So one quick follow-up.
Yeah.
So if, we trying to pass something through the legislature, right. I expect there's several different beliefs amongst probably even this committee, but certainly the legislature as a whole on those 3 topics. Some of us may strongly support 2 of them. Some may support all 3. Some may support 1. If we as an Ohio legislature were to craft one that said, we agree with 2 out of these 3, and other states agreed with 2 out of the 3, can we just do, would that count towards doing 2 out of the 3? Or does it, or would you have to start over with everybody just doing 2 items?
Mr. Chairman, the best answer I give you is we throw dust in the air when we don't need to. And so it creates uncertainty. We'd have to litigate that, frankly. And I don't want to have to litigate. I mean, people can file a lawsuit that's just nuts. I want to eliminate reasonable litigation. And so I would make an observation and a suggestion. The observation is, we're agreeing on an agenda, not on an outcome. And so, I mean, I'll tell you from testifying in, I don't know how many state legislatures now, lots. One of the most popular ideas in our application among people is term limits. The least popular idea among legislators is term limits. And so, there you go. Now, who's going to ratify this at the end of the day? Legislatures are going to ratify it. And so if a term limits proposal gets 26 states to vote for it by delegates appointed by the legislatures, it's going to go out, and then the legislatures, you're going to get 38 states to vote yes? My guess is that's going to be a big uphill battle. And so whether that one happens or not, I don't know. Now, my suggestion would be, and what you could do, and what I would ask you to do if you're considering something like this, is to pass it verbatim and then instruct the Ohio delegates to not vote in favor of any term limits proposal. Other states have done that exact thing. And so you're keeping the resolution so that there's no aggregation problem, but you're bending the course of the discussion in a particular direction that, if that's your concern, you can bend the course in that way.
Representative Humphries with a question.
All right, thank you, Mr. Chairman. And again, thank you for hanging in there. Lots of questions today. I'm going to be brief. My question is, and I think you touched on it, but I'm going to ask it again. We're talking about topics discussed at the convention. And my question is, I know that there might be like a wide variation, but what are some of the topics that would be discussed at a convention by the delegates? Because we know the language is sort of vague. So just real quick, just wanted to know.
I'll give you 4 examples of things that I think can have political, realistic ideas behind them, and they're not crazy. One would be a single subject rule on Congress, to say that they get rid of these multi-thousand pages of omnibus bills that throw everything in the kitchen sink in them. No, one single subject. 41 states have a single subject rule. Congress should have a single subject rule. I think that has legs and could get ratified by 38 states. The treaty idea that I said earlier, that all treaties have to be ratified by the Senate, I think that has value and could get ratified by 38 states. I think that limiting the power of the federal government vis-a-vis the Department of Education is going to be a closer call, but I think that you probably could box the federal government out of the education business, not counting military education, not counting the District of Columbia, but vis-a-vis the states, you could box the federal government out of education, and that has a better chance of being ratified other than, some of the other topics. I would like to fix the Commerce Clause and the General Welfare Clause to go back to the original meanings of both, which is if the states can regulate it, the federal government can't. If the states can spend money on it, the federal government can't. That's the original meaning of both of those clauses. And 99% of the way the federal government has gone awry is violation of those 2 clauses. And so that's my ideal, but getting those ratified, that's a tougher chore. And so, but those are some examples of things I think are realistic.
Representative Brown with a question.
Thank you, Chair. In Ohio, our Constitution does provide for a single subject rule, which we ignore all the time. We just did ignore it not too long ago, which I pointed out on the floor of the House. I've pointed out many, many times. So I don't think the notion that we can have a single subject rule is really going to provide any real guardrail at all, because we have it here and we ignore it with impunity.
Mr. Chairman,
I think
may
that was a
respond?
statement, not a question, but you're welcome to respond.
With impunity?
Mr. Chairman, Representative Brown, let me write it and I'll fix that problem. Because, the easiest way is I would write into it taxpayer standing to challenge any litigation, because the biggest problem with violations of those is who has standing to challenge the violation of the rule. If you put right in a rule that says any taxpayer of Ohio has standing to challenge the violation of the single subject rule, all of a sudden you got a real rule. And you could do that at the federal level as well. And there might be other things that we could do. We need to study that, why this has been abused in some states. And you're not the only state that said that. But I think you could write it correctly, because it is a good rule. And your frustration tells me you agree with the idea that it is a good rule. It should be used. And so you and I work together. We'll get it written correctly.
Thank you for your testimony. I appreciate you being
Mr. Chairman,
with
thank you
us
so
today.
much.
Just for clarity, and so everybody knows that we have 18 more presenters that I know of. That one took 45 minutes. I'm fine with that all the way through the rest of the day, but we finish about midnight, 1 a.m. I'm in if that's what you want to do, but collectively, if we can condense our comments, shorten our questions and our answers, we'll be in good shape. And I think we will be. They'll go faster after this one. The good individual took most of the questions, I expect. So the next presenter we have is William Scott. Is Mr. Scott available?
I certainly
Thank you for being with us.
Thank you. And Good afternoon. I had written down good morning, but as you said, it's now afternoon, so good afternoon. Chairman Peterson, Vice Chair Thomas, Ranking Member Humphrey, and members of the committee. As I said, my name is Bill Scott. I'm from Dayton, Ohio, and House District 38. I serve as the State Director for Convention of States here in Ohio. We're a nationwide organization, nonprofit with over 5 million supporters, and more than 2.5 million Americans have signed our petition for the Convention of States. Right here in Ohio, we have 113,000 of those who have signed the petition. Today, I'd like to talk a little bit about the purpose of the Article 5 Convention and why it's in the Constitution. The founders established 3 branches of the federal government with checks and balances to limit powers of each branch.